Yes.
All right, I will be on.
Please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right. Thank you all very much. Mr. Cacciatore.
Welcome back. Today we have, I want to say a special treat, but it really isn't. We have a marathon of a hearing to get through. This hearing probably should have taken 15, maybe 20 minutes. Instead, it took an hour and 45 minutes. 47 minutes, actually. So, this runtime is going to be a mess. Buckle down, get you a snack, get you a drink. It is 12:33 when I am starting this. So, apologies if I stop making sense halfway through this. Disclaimer, this is all commentary. I don't have time to try to edit this down. It's going to be what it's going to be. So this is not the video. If you want to just see it all the way through, I'll put that link down below. But let's get into it.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 101077.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is...
You thought you had a few things to address this morning. You actually have 1,500 things to address this morning.
Is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Great question, Your Honor. I'm actually going to steal that. If everyone out there in the states and the nations and the countries and the worlds have not seen either Sarah Boone's motions or JAC's response, then you should check out this video right here. Hopefully I remember to put in the little link, and it'd be like really cool if it's in the corner. It's like, I finally did the YouTube thing. And if it's not, it's like, I didn't figure it out and it's too late. So anyway, watch those if you want to know more about those motions. And now the judge is going to finally respond to them.
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with the, y'all can be seated, you don't need to stand, thank you.
Could you imagine standing for this?
The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29th, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those, as to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it.
And that's really good to have on the record because it shows that everyone involved in this case is trying to help her and that they are trying to give her resources So when she tries to appeal this later, it's not that she was just ignored the entire time.
State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them.
He accidentally misspoke there. He meant without prejudice. The difference is when you dismiss or deny something with prejudice, that means you can't bring it back again. And when you dismiss it without prejudice, that means you can make your corrections or you can retry the person, resubmit the motion, whatever have you. It's what we saw in the Alec Baldwin trial where she dismissed the case with prejudice, meaning he cannot be retried for that charge. So she now can go make her revisions and change it from TBD to literally anything else and then resubmit it.
And you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
He knows that is the most loaded statement of this entire hearing. Of course, she has questions, comments, statements, insults, complaints.
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial.
Now this is the big one. I know, Train, right? I know. This is the big one. This is the 29-page motion that she submitted trying to get standby counsel, citing the 6th Amendment at least 30 different times, saying that it's her constitutional right to counsel and this is standby counsel. This is what we've been waiting for. So,
The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant.
read her.
Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is incenting not to get involved until the defendant says, I no longer want to represent myself.
Period. And there it is. It is not your assistant. It is your tag out.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul v. State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
That silence is loud. I think he was expecting her to just jump across that table or something, but wow, that pause was awkward and excessive.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment.
She's swapping the words forfeit and waiver. You didn't waive it, but you forfeited by the way you acted. Sorry about it.
And also, I feel that I should have had some type of evidentiary hearing prior to your decision, so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So
I bet you don't. I bet you don't. We all know that you don't, and we all know that you wouldn't have. That's not what any of this means. I do not know how she has not put that together. She has to have, but I think she just thinks if she keeps saying it, then that changes the reality.
So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand.
You were warned multiple times about the dangers of self-representation. It wasn't a joke, even though you thought it was funny and you thought you could just write it in your little letter saying that you threatened me with it. as if they wouldn't do it, and now they did it, and you're shocked that they actually did it after you've been daring them. They told you that if the behaviors that continued that resulted in you losing counsel and having counsel want to withdraw continued, that you could risk the dangers of self-representation. What were those behaviors that caused most of those lawyers to want to leave? Angry letters where you say that they're breaking the rules, accuse them of crimes, and altogether just tarnish their reputation in order to force an action from them. And what did you keep doing? You kept writing the letters, and you kept getting bolder. Every letter kept getting more and more bold, and then the last one, you submit a 58-page letter, and I think that's when he was like, yeah, this is never going to end. No matter who it is, she's going to give me a novel next. So that was the nail in the coffin in my mind, was the fact that she never learned her lesson. If she had stopped writing those letters, she would be going to trial with Miss Cashman. But she didn't. She kept the same behavior she did with every single other attorney. She treated every single attorney the exact same way. And that is how we got here.
So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's right away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Ferretta is for people who can make a choice. You cannot.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now, my belief was that the evidence or the Ferretta hearing was simply competency.
Your belief of how law works doesn't matter. He already explained to you how it works, and you're coming back with, well, what I thought was, I don't care. I already told you. Shush, shush.
So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
That answer doesn't make sense. You're basically saying that I wrote my letters to prevent having to represent myself. Meaning I knew that if I didn't start writing these letters to you, I was going to get worse and worse and worse until I had to represent myself. That's the logic that you're stating. That's not what you actually mean. But she's spiraling. So she's just trying to make this make sense. She's like, you did this in retaliation, which it's like, you can kind of see that, but it's actually just a consequence. They told you what would happen if you put your hand on that hot stove. And you said, okay, well, I'm going to put my other hand on this hot stove. And you're mad that you still got burned. She still thinks that having a meeting would have changed the outcome. It wouldn't have, because this is based off of your prior behavior. Anything you would have said in that moment would have just been lip service, and it wouldn't have changed anything. I can guarantee you that. But she's saying, you only retaliated against me because you didn't understand what I was saying in my letters. And you didn't understand, you idiot. You didn't take the time to know what I was saying, because what I thought I was saying was so simple, but maybe a dumb... Okay, you're right. I'm being petty. You're right. I'm sorry. That was on me. But basically, she's belittling the court, saying, if you actually understood what I was saying, you would have agreed and voted the way I wanted you to vote, and you would have obviously given me another lawyer to abuse.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
You wrote the letters. Those letters were supposed to be you explaining yourself. Are you saying you wrote letters just to prompt the discussion in order to explain yourself if you got a response? No, he did listen to you. He listened to your words. He didn't listen to another BS story you were going to make up in front of him while you're calling everyone else around you liars. All the people who take oaths and whose jobs are actually tied to telling the truth, they're all lying. And the one inmate on trial for second-degree murder is telling the truth. Okay.
I'm not going to revisit my prior decision.
Period. Stand on your business, Judge.
I understand. I'm just trying to make you aware that it's my opinion.
You wouldn't, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant.
Y'all, that was just responding to the motions. That should have been boom, 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 boom. Now, we are only now getting to this discovery, which originally was supposed to open this whole thing.
Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st.
You heard it here. Buckle up for a 3-week trial. If you remember back when Ms. Cashman, they were setting the timeline, the state said they needed 3 days. She said they needed 2 to 3 days. They had set this up for a week. Now they are setting it up for 3 weeks. And they know they're going to go into it. There's no way they're not going to go into it. And to be fair, it does somewhat make sense because she will need to be explaining things as we go, but just damn.
October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21.
This is actually really good to put on the record because they're saying that they're giving her special treatment. They're saying that we don't want her to be rushed with the other inmates who have the exact same rights and legal constitutional rights as she does, but they're making exceptions to make sure that everything runs extra smooth for her, which will look better for them on appeals court.
Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Yes, say it all for the record, giving her even more special treatment. So she can't say that she was so disadvantaged and that they didn't care. I mean, she's going to say that. And she's still going to complain about it. No matter how many extra things they give to her, it's never going to be enough for her. Because it's not exactly what she wants and how she wants. So it's unjust.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided.
Some of the documents, counteracting her narrative of, I haven't seen anything ever. We all know that's a lie. Cashman said that your notations were on your medical records. Every other attorney says that they have shown you different things. You do know what is mostly there. So pack up this lie and take it back to your cell.
I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive. They could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially.
He's basically asking, do we have to show her all of the discovery or just our exhibits? The court has said just the exhibits, but he wants to know, does he have to bring the stuff that could be brought in and not just on their list? Like we talked about prior, there are some things that are admissible, some things that are not. However, doors can be open, things can be said, things can happen. That does allow for inadmissible evidence to be admissible. So, but that's all in your discovery. Even though it's not listed at their exhibit, you still had it in your discovery. So he's asking, do we have to bring the entire discovery for her to look at just so she can see everything that could be a potential exhibit? Or do we only have to show her the exhibits that we plan to do? And the court is going to say just the exhibits that you plan to do.
Not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense, and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Yeah, if we're going to make this work for an October 7th trial date, Judge, I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality? It is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail, and I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes opened in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and we can put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it, the conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code.
Plea negotiations. He is spilling all of her tea. I will bet my whole salary that she did not want that information out there, that she is looking into a plea deal. Wow. Yeah. I mean, at once upon a time, so if you don't know, she is facing second-degree murder charges, depraved heart murder, which can come with a life sentence. Honestly, I think that they are going to offer her life with parole or something like 30 years to life, something like that. Because the nature of the crime is heinous, right? Just because she's annoying and has been a pain in people's side doesn't mean it is still not a heinous crime that deserves just punishment, and you don't get a lighter sentence just because you nagged people. So, but it's also in the interest of justice, and you would be sparing the family a trial, so they would take all of that into consideration. So, I don't know what they would offer her. I would offer life with parole. But I don't see her taking anything because then she has to admit guilt, and she does not see herself as guilty. So, we'll see.
And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial, and either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is
So
correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom.
And this is not necessarily her fault because she just doesn't know what you don't know. You don't get to just take evidence with you into a dark room and review it. You will be viewing evidence in front of people in the light of day with 1,000 eyes watching you in Ziploc bags that immediately go back in the bag and go back into evidence. Because if the chain of evidence is disrupted, then you get to say, oh, it was altered at this step or that step. So they make sure that there are eyes on the evidence at all times. She wants to go into a private room where her and the investigator get to comb through everything and then make their own notes and then come back with the evidence and then come back with their objections. Sorry.
I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media.
He has already addressed this. He says he's going to try to get the media out, and they're probably going to allow him to keep the media out because you have been getting special treatment this entire time, even though you say you haven't been. So the media will not be there. Yes, you need to do it in the courtroom. They can't send you anywhere else. And he needs to be able to make a record of every single thing you viewed so you don't get to go to appeals and say, well, I didn't look at this or I didn't look at that. Because if you go into a dark room or whatever, side room, not just literally dark, you get to say whatever you want later. So he is not going to let you scoot out of anything. You will see everything in front of him, and he will put on the record exactly what you touched, when, where, and how.
I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go as answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
And just so that the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever we deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence.
And the physical evidence is different than the discovery. The discovery is just all the stuff. It doesn't have the physical evidence in there. It has the descriptors, the scans, the copies, the reports, all that stuff. But she's asking for removal and looking at the physical evidence, which no one has unfettered access to. Even the state has to go through wherever to get the evidence. So it's not like they just have free range access to it. It's not hard for them to get to it, but it is not in their office just sitting in the back being kept away from her.
So CSI would have to be here, just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
The judge is right. The state literally just went through and told you how it's done and how the lawyers also don't get to do this in private. However, his answer almost seemed a little snarky, but it wasn't, because him answering that could have crossed the territory of giving her legal advice, which he cannot do. And telling her the process of how this works is kind of giving her a direction or implying different paths that she can or should take depending on how the process is normally done, and that would be giving her advice as to what to do.
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
And again, please, yes, because he's already explained this. He says he has to look into if he can actually make an order to keep the media out. The answer has been given to you multiple times, but it's not the answer you're looking for. Unless he gets down on his knees and says, I swear on my life that, well, no, we're going to take Sarah Boone's example. I swear on Sarah Boone's son's life that I will make sure the media will not be in there. And if she doesn't hear that, then you have not answered the question. He is going to tell you yet again that he has to look into a motion that he can file or whatever in order to keep the media out. He does not have an answer at this time, and that is not going to be okay for her.
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised.
Yes, you in your years as a pro se esquire have never heard of a case where this has happened. So then it just doesn't happen, and it's not true because you don't know about that. And you're going to tell a judge who looks at hundreds, if not thousands, of cases in their time how this is supposed to be run. Whew.
So, if you could please look into that, because I disagree with the media being involved in that.
How many times does he have to tell you that's exactly what he's going to do? He's going to look into it because he as well does not agree with the media being involved in it. And this is what we're going to see this whole trial, where people are agreeing with her and it's still not going to be enough, where people are going to be doing exactly what she's asking and she's still giving them attitude.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. we are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing.
That big sigh. You could tell that there was more that she wanted to say, but the judge is moving on. I will say he is handling this beautifully. He is keeping things going. He hasn't lost composure. He's not going into the weeds with her and is staying very short and to the point. A+.
For Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the after our viewing here in court, State, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that, and I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us, and so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior, before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are.
He said if there are discussions to have about a plea deal, meaning they're not going there with the intention to offer her something. I mean, they will go there to offer her something, but they are not going to her. She is asking to meet with them to see what they will offer her and then maybe try to negotiate back and forth. But if they say the lowest we're offering is life with parole, and you can go to trial and risk life without parole, then there might not be a plea at all. Odds are they might have a nicer plea of some kind, but I would be shocked if the longer end of the plea wasn't life, given the heinous nature and just the malice behind it, which is clear in that video.
And then also we can let her know, and probably provide the court in writing, the list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
I think it's funny how she always says she understands when she clearly does not understand, and then asks the question that's basically stating that she does not understand it.
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane,
Okay.
who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process.
Thank you.
And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail.
Girl, what? That's where you live now. That's like saying UPS, don't come to my front door. Come to me, find me somewhere. No. They're going to have to deliver it to the jail. There's nowhere else to deliver it. Whew. She has ideas of how she thinks the legal system should run, and because those are her ideas, then it needs to run that way. And she's going to keep trying to warp the rules to fit her expectations. However, she didn't want to do that when she was weaponizing the law against other people. She wanted everything to fall that way because she knew how that system works. Now she doesn't know how this system works, and she wants it to conform to how she wants it to be. Goodbye. And yes, your jail phone calls are released. Everyone's are. Everyone's jail phone calls are recorded. It tells you right when you pick up the phone that this is recorded. The judge can go and listen to those calls at any time they want. And sometimes they do for sentencing. That's what happened with Hannah Gutierrez from the Alec Baldwin case. Of all of her jail calls showed how unremorseful she was. And I think, who was it? Ezra something? I don't know. She was a murderer or something. But her jail phone calls and or letters were very self-incriminating, and they were all out there because that's how this works. That's how this works. You lose that right to privacy when you are an inmate. She said she has a right to privacy. You don't have a right to privacy. You have a right to confidentiality. Slight differences. Privacy is your own personal space and your own personal construction of privacy. Confidentiality is we have an obligation to make sure this specific information does not get out, not that you feel like you are secure.
I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much...
Who was that, ma'am?
Good. Get her to put names on the record. That way you get to go fact check them and say, did you tell Miss Boone this? And then when they say they didn't, they get to be like, why did you lie in open court? Yes. This is a huge manipulation tactic that people use a lot of imaginary credibility out there. Well, I talked to this, or this person's out there, and if you just talk to them, because 9 times out of 10, they're assuming that you're not going to do it, and you're just going to take their word at face value in that moment, and then try to follow up, and at that moment, they can come up with another lie to justify why those stories didn't line up. No, Get her to say the names on the record, and so she is locked into that answer.
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
T. Giovanni?
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included.
What is she even saying at this point? Like, this doesn't even make sense anymore. Now it's just a simple laptop that we can use. Girl, they told you what the protocol was. They have it set up. It is going in these places, these places. You're not going to usurp the jail and start telling the jail, well, this is how you need to start handling. No, they are in charge of you. You are not in charge of them. You do not get to dictate their protocols. They are going to inform you how things work. And that's how things work. Unless you have some valid thing that you can bring up to argue against it, but you just saying that's not my preference is not enough. Nor should it be. Because then you're never going to be satisfied. And if you're noticing, she is, again, changing the goalpost ever so slightly. Anytime they give her a clarification, then she changes it a little bit, asks it a little differently, just so she can remain unsatisfied with any outcome.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding.
Your understanding is not important. The judge is telling you how it's going, and you are saying that you have a different belief because you were told different information. That's not saying you don't understand what the judge is saying. That means you don't agree with what the judge is saying. He's telling you how it's working. That's how it is. All this extra background information about these sergeants back home and all these guards and people, they are not the judge. They don't make the actual decisions. They can give you suggestions based off their experience and what they've witnessed and what they've seen. That doesn't mean that has to apply to your case. Nothing applies to your case anymore because of where you have taken us. Where we are now, they have to create processes for you. They are always adapting. So whatever you learn is not always going to be the case, nor does it have to be.
Because my contacts from the jail are telling me something different.
Who? What are their names?
Yes, get the names. Yes, I love this. I love this so much.
There's multiple sergeants.
What are their names?
I'd rather not get them involved for fear of harassment or anything from.
Oh, goodbye. Get out of here with that. I'd rather not get them involved. That's why I'm just telling you that they told me. If you didn't want to get them involved, you wouldn't have brought them up in the first place. This is how you know it's all full of it, because she doesn't actually want you to go back and check. She just wants you to believe that these mythical leagues of sergeants that are on her side all of a sudden are telling her all this information that goes contrary to what the judge is saying. No. You brought them into this. Tell me the names, or else keep that argument to yourself, and I don't want to hear it.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning.
I know that's right. Stop her mid-track before we even go down this road. Because the fact of the matter is, would you tell us if you did? Even if you did get the list, you would still say you didn't. Because you can't be satisfied with what they're doing. Because you'll be like, well, I didn't know what that list was for. No one sent me a notice telling me what this list would be for. So I didn't know I was supposed to keep it. And now I need a new list and a certificate of service telling me what this new list says.
Just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive
Okay.
option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail?
Mm-hmm.
Yes. I actually have 3 motions, please, if I may submit them to you.
Oh no, not even more motions. I'm still recovering from the last video.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied.
Oh, she got bitey with that one. It is incorrect. It wasn't actually incorrect. It is like her standard P.O. box. However, it was not the correct legal mailbox. So, of course, that means they did it on purpose, maliciously, against you. It is incorrect because they hate you. And, that was just biting back. It's incorrect because she needs a win. So she needs to be able to say that the court is doing something wrong. And that's something that she can prove. You had the wrong address, see? And it was like, yeah, clerical error, messed up once, won't happen again. But I promise you, you will hear about this time and time again. That you messed up my address one time, so now I have no trust in you. I can't ever trust that anything is going to be done because you had the address, and no matter how many times he says it's been fixed, she's going to bring it up again and again and again because that is her one little win of, see, I caught you in a mistake, and now I'm going to rub it in your face as many times as I can, especially when I feel defensive.
But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail, and Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state, and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
They are not there to make sure you feel protected. They are there to protect the evidence in the chain of custodies. They are bound by their own laws, regulations, and oaths and conduct. They are not there to make sure that you feel protected. They are there to actually do the protecting. So whether you agree with them or not, or think they're shady or not, they're not there to hold your hand and make sure you feel good going into trial. It is not their job to make sure you feel ready, confident, and excited to go to trial. If you feel miserable every single day you're up there, that's fine. As long as they are protecting your rights and protecting the things that you need and have access to, that's all they're supposed to do. They're not there to coddle you. You still do not get, this isn't summer camp, this is a murder trial. It does not get more serious than that, and you do not get more pampered than you already have been. Actually, you will be. They will still give you more benefits of the doubts, and you'll still not care at all. So even if they didn't give it to the jail, no one else would be good enough.
Okay. The court's going to follow the procedure as I outlined at the last hearing.
Period. He said, take your feelings to the confessional. I don't have time for it.
So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Can caveat in that order be unless it hasn't already been done? In case we do it ahead of September?
Sure. If you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place.
Understood.
Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th, and if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get past that.
And what is your affiliation with the state?
I am the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
What she's not getting, and honestly, I'll give her the benefit of the doubt, this is kind of confusing, is that hearing is with a caveat, if necessary, meaning the judge is giving the deadline of September 3rd. He wants this digital evidence to have been exchanged. He wants her to be able to look at it so that 14 days later, she can lodge her objections. either on September 3rd you come to the courtroom and you do it there, or the state is suggesting that they could do this way quicker and just meet her and do it however they're going to do it and record it however they're going to record it. Now she's saying, oh yes, I would love to meet with you so that we don't have to waste time on the 3rd. There will be no 3rd if they do it before then. If they don't, then they will all come into court on September 3rd and do it then.
I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get up?
Okay, but that was shady. He said, I assume you have availability.
Later this month?
Yes.
Then you can do that, and like I said, Mr. J, if you could file that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to, well, I'm in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quote, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
She doesn't know where she's going to be able to view it. They said they had that classroom. Maybe they'll be able to let her use it or something like that. But that's why it's on the laptop and the computer jump drive. Of course you don't have a laptop yet because you don't have the discovery. You only get the laptop to view the discovery. And if it has internet access, then it has internet access. But that's the only reason you would have the laptop. It's not you get a laptop and then eventually we'll get you the discovery when we can. I get it. You're waiting for it. It is slow. I'll agree with that. But again, it's not like you don't know what's in there still. You can start outlining things with the stuff that you know is in there. That way, when you get the stuff, you can get straight to work. But no, you're hoping that the answer lies within this mythical discovery that really is only going to show you how effed you really are. And then you're going to contest it being like, well, that's not what the evidence is. It's like, okay, the facts are what the facts are. Now she's complaining about not having access to the computer long enough. 8 to 4, that's like a standard work day, 9 to 5. You don't get unfettered access. A thing that she also always forgets is that she always wants to talk about her own constitutional rights. She is an inmate just like every other inmate in there. They all have the exact same constitutional rights you do, and no one is better than the other. So you don't get all of these exceptions made for you just because you're now representing yourself. Everyone has to abide by the same rules and regulations. So if they can give it to you from 8 to 4 without causing conflict, that's what they can do. But if they start making all these other exceptions that allow you to get all this extra time away from this and that and can cause disruption against the other inmates who could see that as an injustice when they have their own cases to try, they're not going to do that. I'm not saying that's the reason they're not doing it, but that could be a factor. 8 to 4, it's good enough. She's probably saying she can't utilize all the time because she has to take meal breaks, but still, calm down. And if she does not check out that laptop for every second hour of every day, that is going to be logged and being like, oh, you only picked this up from 12 to 4 on this day, so you didn't use your whole time. So you can't say you didn't have enough time unless you use every single minute of time. You got to corner her in her own game. And no, you cannot have a hard copy for the exact same reasons they said the last time. The whole reason this entire process was created is because they cannot house the hard copies. They cannot allow you to have all the hard copies. There's probably different rules and regulations about what is allowed in the jail, whatever. You're going to complain about confidentiality. They can't not assure confidentiality if you ask for these hard copies. And then you're going to say, well, I don't know where to store it. You are asking for it. If they told you up front they don't have the room to be able to give you hard copies, you're going to beg for hard copies and then be mad when they can't store them. So no, it's these cyclical arguments that are going to keep going round and round and round, and they're going to play her game. They're going to play it all out until she runs herself into her own corner and all the questions that she asks have been painstakingly answered, and still nothing changes in her favor.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by us bringing that topic up, I have that to also be looked over.
Okay.
Please. 917, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that would give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make any type of deadline.
Well, we're setting them today.
I understand. So the 3rd is a what day? Thursday?
Tuesday.
He has reached his limit of the longer explanations. It is short and simple to the point. We're setting deadlines today, not this if, ands, or buts. Setting it today. What day is it? Tuesday. He's not going down any further explanations. It's going to be straight and to the point and only to answer what you are asking.
So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
She's making it sound like a rhetorical question, but no. Finally, yes, you are getting everything right. That is exactly what you have left. This has been set in stone since you became Sarah Boone Esquire. You have just now caught up. Congratulations. Everyone is here. Yes, we are moving quickly. And she keeps holding on to this argument of the discovery. I promise you, there is nothing in that discovery that is going to save this case. Everyone knows it. That's why the state is not pushing back at all, still trying to get her this discovery. It's just taking a long time. No one is worried about you seeing it because it's not going to help you. I promise you. So making this argument is going to run flat in the end. You no longer get to stall. because that's all you've done for years is stall. And you can't do that anymore because no matter how much you want to beg and plead, you have
62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
work. That's right, Judge. Don't even entertain it. Because what is that? After 4 years, yes, that's the point. After 4 years, it has come to the point where you have to represent yourself. He's not going to answer that question because the answer is yes. You want it to be something different. You want people to see this as an injustice when you have gotten way more chances than 90% of people will ever get in their criminal murder cases. So, wow. Yeah, wow. Wow is right, because we're still here waiting for you to go to prison. But you will do anything you can to draw it out as long as possible. That's why Kranick is pushing this through, being like, at this point, let the appeals court deal with this afterwards, because the case is so airtight and his logic is so justified that yes, even if there's a little here, wishy-washy things that's like, oh, Sarah can bring this up in appeal, it's not a strong argument. Just because there's a good argument, there's good arguments in appeals courts all the time, in appellate courts all the time. It has to warrant a new trial and warrant seeing the cause that the judge made as incorrect. And I don't think that's going to happen here.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I understand. I just don't understand. How many times is he going to have to tell you he cannot give you legal advice? Look it up. If you have a library, look up a law library. You cited all that law in those motions. Look up in the dictionary, how do you file a objection motion? Which the JAC guy, the little floating head that looks like Zordon on the projector, he said that he's going to give you a pamphlet full of motions and models to help you get through some things.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. Those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order.
Yeah, I have no idea what she means by delegate. There's no one to delegate anything to. There's no other representative. You are representing yourself. You delegate to yourself. Like, she just basically asked, so are you going to make me do this like everything else? Yeah, you will be doing absolutely all of it. Why? Because you took all the help you had for granted. You insulted them. You came after their careers. You called them libelous. You said that they were perjuring themselves. You came for their credibility, all that stuff. So now you get to sit in the hot seat and you get to be delegated all the work in your case as you complained about in every single letter. When can I be included in my case? When do I finally get to make my own defense and really put on my case? When will I finally be incorporated? You cannot be more incorporated than you are now, and now you are trying to scurry away because you realize you never wanted this.
It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet.
Exactly. You haven't provided any other counter to things. They have told you the dates and you have said, those dates aren't fair. What if I want to change them? You haven't thrown out a single date. You haven't said, those dates aren't fair. I don't want it on this date. I want it on this date. I don't want it on September 14th. I want it in January 24th. I don't know. You can throw that date out there. It'll get denied, but you haven't asked for a single new date. You're just complaining about it. He can't infer this for you. He can't give you legal advice. He can't fill in the blanks for you. If you don't ask for it, if you don't object to it, it will come in. It will keep going. And there's going to be stuff that comes out in trial, and I already know she's going to have objections and being like, well, this person shouldn't have done this, and I went back and I researched and realized that this was actually really bad. Yeah, you didn't object to it in the moment, so they get away with it. And you can't say anything about it because you did not object in the moment. But then that's going to be, she's going to use the opposite, and she's going to object to everything, and it's just going to have to get overruled a million times. But at least then she would be trying to protect some kind of record to say, at least I tried. Appeals court, do something with this. Or her free appellate lawyer that she'll probably abuse after this, please do something with this. I've objected to absolutely everything. This is so wild.
You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else if they just delegated the dates and gave me a printed copy with your order and whatever information you have. I don't know.
Exactly. She wants them to do it for her. She wants them to come up with dates that she can pick and choose and say, actually, this one works. Or she's going to say, actually, I don't like that time frame. Can you come up with no? No, you have to come up with it yourself. You don't know it. Again, that's why they said the dangers of self-representation. Dangers. You still never took that warning seriously. I bet you wish you can go back now and take it. And I've never been pro se. Most pro se defendants have never been pro se before. Because odds are, if you've been pro se once, you don't want to do it again. Even if you are a lawyer. And it's all because of her own actions. And she's still going to say that it's unfair, just like she's going to say this whole trial is unfair. She still will not accept responsibility that her own actions brought her here. She's completely lost sight of George in all of this. And he's just like going to be such an afterthought. I mean, the one thing I'm not looking forward to in this trial is just her bashing him uncontrollably to make it seem like he was too inadequate or caused his own death, even though she did nothing but help him. And then she's going to try to talk away the video. Okay, rambling, sorry.
I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I don't know I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question.
She's asking, what happens if I'm unprepared? That's like going up to a teacher and saying, what happens if I have no idea what's on the test? Do I not have to take the test? No, the test is still on the date and you just failed it.
I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right.
My God, we probably spent maybe 40 minutes trying to get that one answer to, do you agree to have your objections in on this date? And if you had lawyers, it would have been 2 seconds. But you had to explain every little thing. You had to argue back and forth, every little thing. This is going to be the whole trial. And I heard Judge Kranick have a sigh. And I'm so sorry, Judge Kranick, we are just getting started. So I hope that you use this to like battle test you a little bit so that you can hold up that armor because you're doing great. I'm going to keep cheering for you.
Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking.
Oh my God, I thought we were done with deadlines. That was just deadlines for the state. Okay, no. Y'all, I have pulled almost an all-nighter trying to react to this. I am going to need to take a break, sleep, and come back to this. Sorry if this gets out a little later than I wanted it to, but wow. I have felt life force draining from me. And we're back. Okay, so I've slept for a few hours, re-energized. Let's knock this out because I'm over it.
I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery.
I don't know if I commented on this before, if he said this before, but he said some documents, meaning he's not even playing this game of, I haven't seen anything yet. Yes, you have. Cashman said that you had notes on your medical records. You have seen many things. She even said your first lawyer went over stuff with you, and you complained saying that was 4 years ago. It doesn't matter what time it was, how long it's been. You are saying you have never seen it to date, which is a lie. Like he said, you haven't seen some things.
So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours.
Yeah, trust us, we know. We do not care.
So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need for you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
And she does this a lot. Again, it's one of those, You didn't answer my question, so I'm going to re-ask it and add maybe a little more information, and you still can't answer it because you just told me you couldn't.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
And the reason he can answer that question, unlike other questions that she asked, is because he's not giving her legal advice. This is just basic information of, does this thing have X, which he can look into because he's not actually advising you on what to do with it.
May I ask your contact names from the jail?
Give us 1 second.
Please, and if also, because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What did I just tell y'all last night, or I guess a few minutes ago for you? That because of this one little error, she is going to run this into the ground. She's going to bring it up every chance she can. Since you got the mailing address incorrect, as though that is not the most inconsequential thing imaginable. People get mailing addresses mixed up all the time. It's not even that they got the wrong address. It was supposed to be just legal mail goes to a different address. So it's not like they were intentionally slighting her, but she's going to bring it up every chance she get, and she's going to make sure that she has vitriol behind it, and so she can try to say, see, I can't trust you anymore because you all can't do anything right. Just how she did when her letter was not uploaded properly and they didn't do front and back and they just did 2 pages instead of 4, and she flipped out for letters on end reiterating that you all mess up everything and I'm the only one who knows how to do anything right. Keeping that same attitude will not help you here.
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know.
And there it is again. She doesn't even know what she's allegedly being slighted as. And this is the same thing with the discovery. She, quote unquote, knows 100% without a doubt that there is discovery missing, but she can't tell you what it is. Same thing here. Did you send me my stuff? What are you saying that you're missing? I don't know. But because you got it wrong, I just know you got something wrong.
Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USD.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. Did what I did? No. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies, you'll be provided digital copies, and to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
She still hasn't given a date. That is what they've been asking from the beginning. Can you give us a date that works for you? And she refuses. She just wants to complain about everything not being good enough, but does not want to actually provide any solutions, because then she thinks that she'll lock herself into that, when she won't really lock herself into it. If you need more continuances as things go on, that's what her lawyers have done, but you have to set a date before you can get there. And she's not going to do it because she thinks that she's signing her life away to that date. And it's like, just throw something out there and revise it later. This is taking too damn long.
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
Another deflection. To be determined is not an answer. That's what you put in the motions. And they just told you at the beginning, going through all those motions, they can't do anything with that. You can't get funding from JAC. They can't schedule things with TBD. You have to put a date out there, or the dates remain the same. She wants people to help her in this. Sorry, you had all the help that most people never ever get to imagine. How many people that they get help for, how many second and third and fourth and fifth and sixth and seventh and eighth chances people get to get help. You had all of that. So you not having resources now is not really that big of an issue to me or to the court, because we knew this was going to happen when you have, because of your conduct, reached this level. Honestly, I think the issue is no one's picking up her phone calls. She wants free range to a phone because she wants to have time to try to convince someone. Because if she had access to someone and can just contact them easily enough, you can reach out to your friends, you can reach out to relatives, brothers, whoever you can. And it shouldn't take that long to at least get them on board or something. I understand you need to go more in depth, but you should be able to contact people to the point where you can get a list of names. You don't get time to research. She wants this, once I get it, I want all this time to research. No, the dates are set. Why? Because you are not proposing a different one.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to-be-determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
Oh my gosh, I completely forgot. We haven't even gotten to the investigator with the discovery. I want to see how many jump drives this had to go on, because he kept saying on as many jump drives as possible, and I want to see all of this discovery.
If the defendant's not going to make a suggestion, may the state?
Sure.
Please, someone, thank you.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence, and 14 days after you've reviewed the physical evidence to provide your exhibit lists.
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
No one's pushing you into anything. They are trying to give you a solution. You refuse to give a date. The state said, how about we do 2 weeks after each time she sees it? So 2 weeks after the digital evidence, she gets to file her objections for the digital evidence, and then 2 weeks after the physical evidence, whenever she sees the physical evidence, 2 weeks after that. Oh my gosh, even when they try to help her, it's never enough. She doesn't care. She doesn't even acknowledge that they are trying to accommodate her. No, you do not have the same accesses or resources. That's why you were warned multiple times, because you would lose all of those resources if you kept acting the way you acted and you kept acting a fool.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards, but there would just need to be a cause shown at that point.
Thank you. That's what I was talking about. Pick a date and then you can revise later. I mean, she hasn't even put in a motion for continuance. So she wants more time. She's put in 5 and I guess these next 3, so 8 motions, and not even one motion for continuance. Would it probably get denied? Probably, but they can't give you one if you don't even ask for it. That's the thing she's not getting. She wants people to give her the options of what she has. No, you have to look into the research and see what options you have and then ask for it. Now, the state is saying that if you have good cause, you can get an extension, but you have to have good cause. She's not going to have good cause because she's not going to take time to think of good cause to why she needs more time or why she can't meet a deadline. If she can get in there, do the work and say, look, I've been trying, I have all this progress and it's almost there, but it's not quite there, that might be better cause. But if you've been twirling your thumbs and being mad and just saying, well, it didn't happen, then that's not giving cause. And you just want someone to fix it for you, when now you must do for yourself.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
You can't have good cause now because nothing's happened. That's like saying to a teacher, can I get an extension on a homework assignment due a month from now? That date hasn't come up. Once you get closer to it, even if you have the same causes or whatever, then you can say that they're a good cause. That it's not a good cause now because there's nothing that is actually delaying you yet. Why? You haven't picked the effing dates. 2, you haven't done anything. Once you actually do anything, you're getting your discovery today, they'll be able to answer the phone issues, they'll be able to answer the internet issues. Once you know what you actually have and you've started working with what you actually have and it's still not working, then you will have good cause.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Ms. Boone.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're seeking out, please, for my exhibits and witness list?
Yes, that is what we have been talking about for the past half hour. We moved on to you. We spent the first hour working with the state's deadlines. Now we are hopefully done with yours.
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right, so the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. And you'll have to provide that to the court in writing by September 17th.
Yes. And if I may ask, please, what you're typing, is that for an order or for today's proceeding?
Why does it matter what the judge is typing? Why are you concerned with everything? You need to be concerned with yourself and coming up with these dates instead of always thinking everyone is slighting you, so you have to know every little thing, even what the judge is currently typing. Oh my goodness, could not be me. Could not be me. I would be in cuffs already.
It is for an order which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
You already know she does. She can't not have a question. So she's going to pull something out. It may not be relevant, but here we go.
Other than what I have made known to the court, I do not.
Oop, I was wrong. I'm happy to be wrong on that one.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here?
Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Donald Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right.
Another smart move, getting that on the record so that she can't say later, oh, he took it, he didn't know what he was talking about. On the record, he is the one handling it, and he says he has knowledge of the process and is the right person to be handling this.
Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those.
Oh, she's been complaining about how much discovery there is, and it all fits on one jump drive. I figured it was. I'm like, they have terabyte jump drives. There's no way they're going to need multiple of them. But I know she is probably rolling her eyes being like, you fit all my 6 tubs into one jump drive? Yes. Yes, they did. That is priceless.
This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
And there it is. One jump drive with her shit, one jump drive with his shit. Which I'm interested to see what the investigator had already had before then. Because I'm guessing they're slightly different. I mean, yeah. But wouldn't that mean he now has to turn that over to the prosecution? Oh, well, no, never mind. That's why he's here. He's handing it over to the judge. My bad.
Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you could proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
You know she does.
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved?
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Okay, that wasn't really a question for him. That was a request, but I guess you put a question mark on it, so it counts.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
Oh, are we finally going to see the boxes? Are we going to see the boxes? There are the boxes. Look at her. Look at her shining. Yes, take the runway. Take your time. This is all for you. Look at you.
Do you see it looks like the
strutting down.
original exhibit tags are still on the top of those? Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Oh no, don't say intent. That might be a trigger word.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I...
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to $10,000 for the investigator, because it sounds like he's already done a lot of work.
Thank you. That's what I was saying. He deserves way more money than what he's getting. So, good on you, JAC.
So it might make more sense instead of having to come back later.
Would that change the original, the $5,500, or just we would increasing $5,000 to $10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from $5,000 to $10,000 for investigative costs, and for travel-related expenses, $500 to $1,000.
Now, why do I feel like Sarah's going to weaponize that against him? Because she did that with Bankowitz in the phone calls, being like, you will get reimbursed by the JAC for taking my calls if you just put in your expenses. Now she's going to be like, you were given $1,000 to travel, so why aren't you here more often and now?
Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Freeman,
Yes, ma'am.
forgive me.
I know she's being polite, but I wish she had that same energy to ask for forgiveness from George's family. Just going to say that.
What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of. I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank you.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
my side
there.
also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order, and like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it was some type of notice. That's what, please, that she was going to print out to give to me, so I have that.
Okay. Mary?
I did not receive that, nor did I receive this protocol list.
As to?
What do you mean? You were just given the protocol list. They said up front, you said up front, you didn't have it, they printed it off, they just handed it to you, and you're saying, I didn't get it. We know that's why they addressed it. This other thing that you're talking about, okay, sure, whatever. They said they're going to print it off, and you're still going to complain regardless. So it's crazy to me. Even when they hand you the copy, you're still going to say, I didn't receive that. Yes, which is why we printed it off and 2 seconds ago gave it to you.
Everything that was being discussed. Can you print out a copy of it for us? It should be in a court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
And while he's reviewing that, we're just going to talk over this for a little bit. Just, wow. This meeting is going as painfully slow as I thought it was. I wish we could send Judge Kranick a gift. He deserves all of the things after dealing with this. And this is just a standard meeting. Like I said, this meeting should have taken at max, and that's if every lawyer is doing everything incorrectly and being wrong. This should have taken 20 to 30 minutes. My runtime right now is at 2 hours. Of course, that's with my commentary, but that's still like, what, an hour and a half or something without it? Just, good Lord. And what are these motions that she's talking about? Did she already bring those up? I'm trying to remember. I don't know. It doesn't look like he is amused, though. I wouldn't either. He just has to sit there and just entertain all the BS.
Well, ma'am, with regard to one of your motions, the motion for defendant's immediate address correction.
Oh my gosh, she wrote a whole motion about the wrong address, about the small address hiccup. What did I tell you? She's going to drive it into the ground. So much so, she said, I got you. I'm going to write a whole motion telling you, well, if you weren't such a dummy, you should fix my address. That's some crazy work right there. You could have been filing a motion for continuance or any other important thing, but no, you want to complain about the inaccurate mailing address. You realize that doesn't look good for you. If you at least filed a motion to continuance in appellate issues, if that was denied, at least you have something. This mail address is not going to bring you anything in the long run. And an appeals court is going to be like, okay.
As I identified earlier, there was a clerical error using the general P.O. box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
He really said, we already covered this, but for your begging ass, here's a win for you. You got what you want. Is that going to be happy? Motion granted. We changed the issue that was very small and minute and inconsequential to anything, but because you wrote a whole motion on it, I have granted it. She still won't be happy. She'll still say, well, there shouldn't have been an issue to begin with, because there always has to be something. And yet again, I'm talking over this while he has to read that mess. That like 2 to 3 minutes that he was reading, maybe a minute, minute and a half, was just over, can you change my address? Now, what's this motion going to be? Probably some more bull that is not necessary or relevant in helping her case at all. I think she's just making up motions. I didn't even know you could do a motion to change mailing address like that. But I guess you can. I guess you can file anything as a motion, even if it's not proper. Now that you're pro se, he has to respond. Just wow. And so I know that judges talk to each other because they don't have many people they can't talk to due to confidentiality. So I know him and Wooten have talked up a storm about this. They also use each other to get advice, similar to like therapists going to other therapists, but like, I mean, they don't go talking about their clients, but judges can talk about different cases.
Mr. J, if you want to approach sir to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case.
Okay, so she wants the pink handcuffs off while she's in the courtroom. Okay, I'm not mad at that, I guess. It just seems like a waste of valuable time that you don't have, those 62 days that you're complaining about, to write a motion for that. But sure, you know, you want to be comfortable in there so you can pay attention and do yada yada. And then you want the hard copies. They already have gone through this. You did a whole motion for hard copies when they said the reason why you have copies to begin with is because, and the reason why it's on the jump drive is because the police cannot, or not the police, but the jail cannot take this stuff in. They have told you already, and again, like she always is, if she doesn't like the answer she got originally, she will re-ask the exact same question until she gets a different answer.
Just review those, Counselor, and just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the Sheriff's Office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
For a second, I thought he was looking at us, and I was like, yeah, I feel you. I'd break the fourth wall too. But no, they're saying you're an inmate. We can't just casually take your cuffs off because you never know who you're in the room with. I mean, she did kill someone. So, you know, she could just jump across the bench and try to zip Kranick into a briefcase or something.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I have written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Please note also, I am in an open bay dorm, living with 63 other inmates. I need to figure out how to view anything securely to avoid further exploitation and mean ignorance. There is no privacy or individual access in jail.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you when you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk.
I love that he keeps asking her who. I will bet money he will march every single one of them into his courtroom and ask them, did you say this? Did you say that? And if they don't confirm that they did, or if she's making it up, that will not go well for her at all. And now she's bringing up a property bag. So they give you a little bag. I don't think that little bag can handle all of your hard copies. But okay. And you also say you're in the open bay dorm, that everyone can see stuff, that you don't want that there. So you don't want people to see stuff, but now you have a property bag that you can keep by your bed, and that would be good enough for the hard copies? No. In my mind, what she wants is she wants the computer in her own private room with the boxes and the hard copies, and then she wants to be able to take select hard copies back to her dorm or whatever and put it in her property bag where it could probably fit. But when it comes to all of it, she's definitely not going to want all of those hard copies of every document on there in her dorm. So even if you gave her what she wanted, she would move the goalpost yet again to say, now that you've given me my hard copies and I can put it in this property bag that I said I now have magically, it's not good enough because I need to store the property bag somewhere. And then we're back to square one.
Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery.
That was not the option. Again, your opinion or what you want is not taken into account when the jail is coming up with its process to allow you to have these files. Of course, you want it the way you want it. They came up with this system on their own. Of course, they were not going to ask you because just like it is now, no system would have been good enough for you. And y'all would have been going back and forth, back and forth, back and forth for months just for you to agree on how you would even look at this discovery. So decisions have to be made without you, and you have to live with it.
I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited, restricted access to the laptop.
He understands because you've brought it up at least 4 or 5 times. He hasn't answered you saying, oh, we will absolutely give you unfettered access to the laptop, so you feel like you need to reiterate it so he, quote, understands it this time. No.
It's from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have.
That's exactly what I said she was going to want to do. She wants the laptop and then she wants the hard copies to take back with her. I understand it, but it is not feasible and she is not getting that.
I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
Holding up the paper, I just now received the protocol, and I know we went over it earlier last time we met. Then you didn't just receive it. You weren't paying attention in the last hearing, and that's not his fault. They went over painstakingly how the process would go, but you were too busy being concerned about certificate of service that you didn't bother to actually pay attention to the protocol. So now they give you the hard copy and you're saying, this is the first time I've ever had it. This is what we're talking about, how she would shift the goal of Bankowitz didn't call me, Bankowitz didn't see me in person, Bankowitz didn't respond to my letter, but you still had the communication in some form, just not the form you liked. You still were given the information. Just because you didn't pay attention doesn't mean that they slighted you and didn't give it to you. I don't know, however, I'm confused at how everyone else is confused that I'm bringing solutions. No, you're not. You're literally only complaining about the solutions that they are bringing to you. If you brought a solution, you would bring a date when you wanted things done. If you were bringing solutions, then you would have actual things to add to the process instead of just saying, I don't have access to this, I don't have access to that, I don't. Not, here's a solution, here's this, here's that. The only solution that you've almost kind of come up with is you saying you want the laptop and then you want the hard copy afterwards. That's still a request, but that's not a solution. You haven't come up with a solution to the reason why you haven't gotten your hard copy. I guess you're saying this property bag is your solution? That isn't thought out. I don't know what conversations she's having with people. I think she's manipulating the sergeants too, again, by changing the question again and again, being like, is there anything for X? And they're like, well, you know, property bags do exist. Great. That means I'm entitled to a property bag to fit all of my discovery in it. And now she's getting here saying that, and they're going to say, that's not what we said. We were just telling her about other examples that happen in different cases, or things that are available, but that do not apply here. If the property bag was going to work the whole time, do you not think they would have gone there first? Why would they create this complicated ass process if they had an easy out with this property bag? But go ahead, let us hear your solutions. Then throwing in, you're drawing the wrong conclusion. No, they are listening to everything you say, and then they are acting based off of what you say. What you say and what you mean contradict each other because you're always trying to win an argument. So every time we recircle back to a new thing, you have a new complaint, a new argument, a new stance on it because it conflicted with what they went for the first time. They try to solve all of your issues up front, and you come back with different issues that then counteract the issues that they just solved. You wanted a place to look at this discovery. They got you a laptop so that you can securely look at it. That's not good enough. I want the hard copies. You know, the hard copies I complained that other people might be able to see and that I couldn't view properly. You're not doing the solution I want. We have this whole building in the compound. Why can't I force you all to give me everything I want and to rechange the system to my needs? It's my constitutional right to force you to do whatever I want, right? Or else you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me in prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, or property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those two bankers boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's two bankers boxes. They're aware of what the information is.
Now that's really going to tick her off, because her whole thing is like, well, the jail is leaking all this stuff. Like, them following the law, she's calling that a leak. But they already know what's in there. So that's not even an argument anymore. It's, you're afraid, you say you don't trust them because you don't trust them with this information because you think it's going to be leaked. Well, guess what? They already know it. And if it hasn't gotten leaked now, then it's not going to. Just because people upload things online legally and request information legally. Your jail calls are accessible if people put in a freedom of information request. That's how that works for anyone. Just because you're new to it doesn't mean that it's unjust and targeting you.
Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs.
I bet it does. I bet it does.
I was never asked anything. Just like my letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
Thank you. Thank you for not feeding into it, because this is just more example of her behavior. She will circle back, run it again in a circle, in a circle, in a circle, asking the same questions again and again. They do not have to ask you. That's why they did not ask you. Your actions, he said, quote, your actions speak louder than words. You putting in some lip service now was not going to save this because of the way you're acting right now. And now we all know how you treated your lawyers, because you're treating everyone else like this. Those lawyers must have been exhausted trying to answer the exact same question. They couldn't get anything done. They couldn't give you any new updates because you wouldn't let them, because you had to keep circling back to the things you wanted to talk about again and again and again, expecting a new answer. And I'm so glad this judge is not playing into it at all. If I've answered it, and that's the answer.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So, if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern, as in Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver, and I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those two bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those two bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
if she moves Ori Tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
Okay, so if she wants to Ori Tennis, which means oral motion, move to release those 2 exhibits, the state has no objection, and it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her.
Sure.
If that's what she wants.
Ma'am, the state has recommended a position in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, he can release them to me?
Granted.
I love this judge so much. Yes, Sarah, that's exactly what they said. They are giving it to the investigator who's going to hold on to it and ask for permission from the jail, who's going to tell him the exact same thing of, no, we can't give you that. We can't accept the hard copies. Why? Because we created this process and told you why we can't. All of this is such a waste of time. And it's because she's lying. It's because she's lying about what these sergeants told her that she could actually have the hard copies, despite the jail saying that she can't. So now they have to entertain this whole hubbubaloo around this and to waste even more time saying, yes, now we're going to release it back to him and we'll readdress it later. They know they're going to readdress it later because they know the jail already said she can't have it. She is saying that there's this new mythic process that they didn't look into that now she can have it. And they said, fine, if you say that you can have it, we'll give it to you. You try to get it. But if they don't give it, we come back here and we have this same conversation again. But they can't say that they didn't listen to her, and they can't say they didn't try to go with her solutions. So they're playing this whole thing out. Crazy work. Crazy work.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pretrial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered.
Oh no, he switched the order of the boxes. I know she's going to bring that up. Well, when it came in here, it was A on top, B on bottom. Now, when it left, it was B on top, A on bottom. Now, that means something was missing. She's going to find anything, and I know I'm making a joke, but she really is probably going to do something like that because nothing can satisfy her. So they did all this, return the discovery, just to take the discovery back.
And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay? All right, thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop,
Yes.
we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents.
So we're going to be back here on the 14th and do this merry-go-round again.
It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to you.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I will set 8, please.
That is the 9th, ma'am.
We're available, Your Honor.
Okay. Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, yes, please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
Oh my God. How many times does he have to tell you he has to look into it? They have answered this a million times. No one has an answer for you about the news cruise right now. News has a constitutional right as well. Like, there's a process to this. Oh my gosh, how many times is she going to ask the same question because she still wants the answer that she wants? And so until you do it, you didn't answer it, I'm losing my mind.
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
Oh girl, get out of here with that. There's no deadline. Whether you find out now or the day before, you do not get to choose whether the media is involved or not. He's going to look into it. If he can do it, he's going to do it. If he can't, he can't. You protesting, you learning sooner is not going to change that.
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom?
Oh my gosh, 4 years later and she's still talking about this damn phone. You are not getting the phone. There is nothing on the phone, the literal hard phone itself, that is going to help you. And just fun fact, if you're ever in jail and they take your phone away, you are not getting that phone back until the end of the whole court process. You can get an imaging of the phone, which is just going to give you a big old stack of papers with everything in it. You will not be touching the actual phone. Whew.
And during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done of your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R.
Not giving you legal advice, but write this name down. See, they're doing everything they can to help her. Also, what they're saying is you need an expert to image the phone itself. You still will never be able to touch that phone, but you can hire this Richard Connor person, and you can plead to the JAC so that they can allow you to image the phone yourself, and then you get your own Cellbrite report or whatever report that he would come out with but you already have the imaging of the phone, meaning everything that is on that phone is in the digital discovery that you have. You already have it. You want the physical phone, you will not get it. And even if you got an expert, he would be able to touch it, or they would be able to touch it, not you.
And then that will be between you and the AAC and him, whether or not he wishes to work for you and at what rate, and so on and so forth. And then that examination would be done by him, with us being present if we wanted to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mere download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
I don't believe that one bit. That's not how Cellbrite reports work. You would have everything. They're not just giving you cookies. They are giving you everything on the phone. The images, the contact list, all of that. So either you're not reading it right, or I don't know, you're not actually looking at the report. There's no way they just send you a full report of your entire phone that is just cookies. That doesn't seem right to me. And no, you cannot physically look at it. Even if it is in front of other people, your hands touching it or getting on it at all would change the evidence. That makes no sense.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline, but there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product.
Yes, they have already looked at the phone. We're 4 years into this. They've done everything. They have been ready to go probably since the first lawyer left. Probably. Yes, they have all looked at your phone. No, it is not an injustice for you to not have looked at it yet yourself, the physical part. And yeah, he's probably right. You were just looking at the wrong file. Sometimes they send over files that have, sub-files inside. She probably just hit the first one and said, this document isn't it. And then there's another document that actually has the entire cell phone imaging. You really need to convince me of a reason why they would send just part of it and not the whole thing. It does not help them one bit to keep that from you. You already hurt yourself enough with that phone.
I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader, and then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that is taken care of.
And
Just
what
as
was that
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then, ma'am, As Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So
Period. You have had it all. Just because you haven't seen it or you don't know how to read it does not mean it is not in your possession. So you can be upset that they're not explaining every little thing to you, but it's there. Figure it out.
you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior, so.
Oh, bullshit. Who are we supposed to believe? The felon who does nothing but lie, or all the lawyers who are under oath saying they have reviewed this with you, or try to review it with you? They have probably given you answers that you don't accept. As we've seen in this hearing, you don't accept things that are told to you. And so then you say it hasn't been gone over with you because you don't accept it. So goodbye with that mess. Just more trying to slander them and just be like they didn't do anything. Don't you believe me, judge in the world? All 8 lawyers did nothing for me. Okay.
This would be a milestone, an epic milestone for me to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy, mirror download of my phone.
I know you can't give me legal advice, but I'm going to ask for legal advice. They already told you you have it. They are saying you are misreading it. So the prosecution is going to go back to make sure that they did send it correctly. Odds are they did. I'd be very shocked if they didn't. And then they're going to tell you, hey, it's there. Just click this icon. But because she hasn't seen it, it doesn't exist.
If it could be brought to you for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, we're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying.
Oh my gosh, they are giving you what you want. They are saying they are going to make sure that you have it. But again, moving the goalposts, it's not good enough for you unless you get that physical phone that you can go with yourself and go through, then it is not good enough for you. They said they're going to look into it and they will make sure you have it. Not good enough. You want the physical. I'm sorry, I'm getting heated. I've reached my breaking point. I'm over it. I don't know how the judge is doing it, but whew, like I said, this could have been wrapped up in a half hour, but we are going through the same shit every time.
No, what I'm saying is there's 2 different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program. And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, you can't. How many times do they have to tell you, no, you can't? Ooh, I need a breather. Let me go get some water. Okay, the water was warm, so we went with Gatorade. But we're hydrated. She is dehydrating me with these questions. So I got a little pick-me-up. Let's knock the rest of this out.
No, because it needs to be a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
talk, I'm trying to talk to the captain. And handcuffs, okay. Your Honor?
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate.
I'm going to answer this for the judge. Hell no. You are not going to be blowing up my email and expecting me to respond. Can you imagine if you gave Sarah Boone your email address and asked for access, and now she has internet to nag you unceasingly? It would probably be 7, 8, 10 emails a day. Absolutely not. No. I would say hard pass. I'll take carrier pigeon over this. The carrier pigeon is always going to make a way into one of my videos. I don't know. It's just a great metaphor. But yeah, I would rather take a carrier pigeon, feed it every single day, teach it, learn how to fly, give it all the love and affection that it needs to prosper, than answer a single one of your emails.
Rather than snail mail, I mean writing you a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already have my address correction, but I don't believe updated.
Are you serious? Are you serious? You brought up the damn address again. How many times does he have to tell you that they corrected the address? Yes, snail mail in jail is correct. It's slow. You can't determine when you're going to get something. You also can't order people to be faster with the mail. It gets there when it gets there. Even if you are down the street, you are putting stuff in the mail people have their own sorting system. They have their own processes. They get there when they get there. And there's so many other people who also have just as pressing of circumstances and timelines, and they all have to abide by the same thing. But you're needling again, saying, one more time, let me remind you that the mailing address was not updated. They told you it was updated. You're not going to believe it, even though they tell you again and again and again. You want them to keep saying, I'm sorry, I'm dumb, I'm an idiot, I can't do anything in life, and I wish that I was half as good as you, Miss Boone, and I'm going to go back to law school, and I'm going to apologize to all my teachers and say that I failed them, and that I'm a terrible judge. And she still wouldn't be sasatisfied.
It's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Why does it matter if it's updated on the clerk's website or not? That is supposed to be your legal address. You're not getting anything you're not getting anything from anyone else outside of the judge. It's not like anyone in the actual outside world who has access to the clerk's website needs to know how to send you legal mail. No.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Good for the record. Keep drilling in that you are giving her special treatment, and you will keep giving her special treatment so that she doesn't have an argument saying everything was stacked against her.
Thank you. And if I do have internet access or am able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is that I might be attached to in order to receive notices to be properly prepared?
She tried this shit last time. She is being noticed. A certificate of service is like a receipt of action. We did this thing. Here's the proof. You are getting notice directly. That is your notice. You think that it needs to be posted on the clerk's website, and that's how you should get the notice. When you go first, they put it up there later. You are getting the notices. I'm so over this argument, and it only makes her look dumb as.
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful, thank you.
Yes, ma'am, thank you.
And that is that on that. We made it through this long AF hearing that never needed to be this long. But this is exactly how long the trial is going to take. She just told us exactly how long she is going to take. The judge released an order afterwards of basically summarizing everything that just happened here. I'm not going to read those since we spent so much time getting through this. But I'm going to have it rolling up here so you can pause it if you want and, take a look at it. But wow, this was just more of the same, such a repeat of everything. She knows more than everyone else. And see, this is that exact same behavior. If he had given her another lawyer, it would never have ended. She is still under the belief, I come here with solutions. I come here with the right answers, and you are misunderstanding me. And if you actually understood me, you would agree with me too, and you would give me exactly what I want. It doesn't matter how many times people explain things to her. She will wear you down until she gets the answer she wants. Can you imagine her in a relationship while intoxicated and physically violent? It all tracks for me. I see exactly how controlling she is. I've seen abusers play victim, and this hits every single marker. It does not mean that she has not been abused. It does not mean she has not gone through things, but she is the textbook definition of a primary aggressor who is aggressive at everything. Even when she's smiling, happy, and nice, it still has this pointed, excuse you, email. That's my work email. That means a student. Who emailed me? No, I have a meeting. No, I have a meeting. Anyway, none of this is ever going to be good enough for her. She's going to stall as much as she can, and she's going to play victim as much as she can. I'm already exhausted. I will keep powering through for you all. I'm not really editing this video because it took me so long. I'm just going to upload it. So if there's any issues, sorry about it. If it sounds weird, sorry about it. Again, I just want to thank you all for all of the support. I really appreciate it. Even if I can't interact with your comments, I do read them all and I do get a good chuckle and I appreciate all the support. So thank you all for joining me on this trip. Like, you all have really increased my confidence, I guess, to keep this going. Honestly, never expected anyone to actually watch or care what I had to say. So thank you. Thank you so much. And remember to comment, like, subscribe, dislike if you're feeling it. Until next time.